call the next matter, which is John Doe versus Regents of the University of California. We could have your name and appearance for the record and spell your last name.
May it please the court, Mark Hathaway on behalf of appellant.
All right,
Hathaway.
thank you.
Good morning, Your Honors. Catherine Incantalupo, Incantalupo, for respondents, the Regents of the University of California, and Brooke Chang. And with me at council table is Catherine Essick, Essick.
Okay, and before you sit, we received the two items that you provided to us with regards to where the case currently is. There was a request for us to remand. We cannot remand. There's been a judgment. The only thing we can do is issue our opinion. If the group wanted to dismiss this case, and we would issue our opinion and then dismiss it, but I'm not quite sure what the point is of oral argument today, other than to try to convince us our tentative was wrong. But I think you all agree that you're at a different stage, that you can now take through the writ process on the final decision.
If the court does, Justice Miller, if the court does reverse its tentative or change the tentative, then it would provide a remedy for appellant, and we would seek that remedy. And I wanted to address the misunderstanding.
Okay, but then that's fine. So then in essence, what you're telling us is we're going to look at the whatever arguments you make today and issue our opinion. That's what we're going to do. If that's what you're all inclined to do, it's kind of up to you, because it's not something you can unilaterally make a decision on. But I'm telling you, we can't remand it. So
Understood.
it's either the opinion goes out, we can't remand it back unless we were to reverse our decision, but we can't remand it at the stage it currently is. So go ahead and take a seat, and you go ahead and you've got 15 minutes. Did you want to reserve some time?
I'd like to reserve at least 3 minutes of my
Sure.
remaining time. And I wanted to address first the misunderstanding of the start of the administrative process.
By who? The misunderstanding?
Well, in the tentative, essentially there is
By us?
Unfortunately, Your Honor, and by the trial court. So I
Okay.
would just state that apparently there seems to be a missing section in the discussion, page 11, before the PPSM 70. There should be a discussion of the SVSH policy. The tentative essentially has the way the process works in reverse. So the tentative discusses at great length how the PPSM 70 policy incorporates the SVSH policy, but it's really the reverse of that. It's the SVSH policy that incorporates the PPSM 70 once the Title IX investigation process has been exhausted. There was no complaint by Jane Roe filed under the PPSM 70. It was under the SVSH policy. And under that policy, which I believe the correctly dated one starts at, in the record at 399, under that policy, which applies to students and to faculty and to other members of the community, the Title IX officer, an investigator, investigates to a conclusion, and if the, on page, in the record on 410, where it discusses the investigation report, it's there where the PPSM is incorporated in the SVSH process. The SVSH process is how this whole administrative procedure began, not the PPSM 70. So under the SVSH policy, if you're a student and the respondent is a student or the accused is also a student, then both have rights of appeal. If you're an employee, and that goes over to, I think on 411 talks about discipline, you have the Title IX investigator, the sole investigator, which has been found to be fundamentally flawed and lacking in due process. That model, that investigator makes the decision, makes the findings of fact, makes the determination that a policy has been violated by the employee. That's the end of the SVSH policy. What happens then is the PPSM 70 comes into play. So where the court's discussion about the PPSM referring to, I think it's 382, in the record at 382, it starts on 381, how do you file a complaint? Appellant can only complain about the termination. They can't complain about the conduct of the SVSH process. That's over and done and final. It cannot be changed. Can't be changed. That no one at the university has any authority under their policy to make any changes to that. So where the court says in the final pages of the tentative that there is some process where nothing indicates that he can't raise issues concerning the investigation or report, that's dead wrong. It's contradicted also.
I don't think we're saying that there's some way or process to change it, but you certainly can raise issues about what was in the report at the hearing, the ultimate hearing.
But then it would be a remedy that, but there's no remedy for that. It would be.
How's that any different with a police report? I mean, you don't get, at the trial, when you're found not guilty, you don't get to go back and say, okay, now you've got to change your police report. It's the investigation in the report.
Well, it would be that, I think the analogy, I don't know if that's
And don't you get to say if it turns out that it's all wrong and you cross-examine all those people and you prevail, okay.
but that exists when the SVSH policy is completed. That then, so under the PPSM, the Title IX complaint is not incorporated into the grievance process.
I think what our opinion is saying, we're not sure there's a distinction, or maybe there's a distinction without a difference, that there's in essence one policy, no matter which one of those you go through. I don't think any of them provide you with the opportunity to go back and say, okay, now you interviewed a witness and they said X, now you have to change that to Y, even though they didn't say that?
That's correct. There's no process to challenge the final decision of the Title IX investigator. And
So that's what we said. So now, there's nothing for us to do. You have to go back and wait till there's the exhausted all your administrative remedies, and you have your final decision from the body, and then you come back to us.
But there's no, the remainder, the separate process that exists under the PPSM 70, which starts a new process that relates only to his grievance of the termination decision. At 195, they state very clearly you can't change the Title IX. It's the Title IX decision that causes the harm. All that's happened in the last 400 and some days that the grievance process was going on is further damages. I think the court talks about exhaustion is supposed to deal with mitigation of damages. It doesn't mitigate any damages here. The university has the ability to simply drag out the process almost ad infinitum, and it did. And the purpose of 1094.5 is for individuals to come before the court and seek some protection from the massive apparatus of government. It's our Supreme Court's words under Bixby versus Pierno.
But then you should have come for an injunction.
Then they would say that there's...
You came here for us to involve ourselves in the review process, and we said you hadn't exhausted your remedies. You didn't come here asking us to issue an injunction to stop them from investigating.
It's not, we're not asking to stop them from investigating.
You're asking us to change what the investigator found.
Well, the court does have the jurisdiction to grant petitioner appellant what he's seeking. Court could set that aside. The findings, it's all in the record. The process is.
So you agree you haven't finished the process. I mean, even in your letter, you agree you haven't finished the process.
The process, he's not disputing the termination. He's disputing the finding to begin with. And the finding is a separate investigative process. There's no opportunity to come before any court and seek an injunction to stop the
So
investigation.
should we publish this case if it stays the way it is? Should we publish it? Because, at least in my opinion, you're asking us for something that's never been done before and that we don't have the authority to do.
Well, under 1085, under 1086, they have to comply with the law and they have to comply with their policy. They've changed now their policy, this SVSH policy, because of Doe versus Ali, because it's been determined to be unlawful, or not unlawful, but fundamentally unfair. And how long should an individual who's, at retirement age, who served
And didn't all those cases come to the court after there'd been a final decision?
Those did, but the process, there's this process that the university has created for faculty and for staff, there's no appeal. So you have an administrative process for which there is no appeal. This is the appeal. There is no other opportunity than for the appellant, in a circumstance where there's a finding can't be changed, it's over and done, has to bring a 1094.5 writ petition before the court. They have no other remedy in order to seek relief. And what this court is, or what the courts are saying is, oh no, all of that's done and complete and the damage is being done, you got to go through this whether or not you're terminated. The termination is nothing compared with the damage of being actively involved in youth sports.
But you agree there isn't any other case that's attacked it in the way that you want. And the decisions that have come out in favor of the complaint have been exactly what you've said. The process was wrong. There wasn't due process. There wasn't cross-examination. There all of the evils that you've talked about, but they did it, whether that's right or wrong, because there isn't a justification otherwise after the administrative remedies have been exhausted.
I would only leave with this thought, is that all of those cases were when the decision of the finding was final.
That's right.
Exactly like this case, where the SVSH policy decision under Title IX is final. It's this separate issue that the separate complaint. The complaint is about the termination. No ability for remedy. There's no requirement for exhaustion because there's no judicial economy. You can't change that. We just have to simply wait.
But I guess I get back to your letter, and it's the second to the last paragraph says, appellant believes there is now no dispute that he has exhausted his administrative remedies and may seek to appeal both the findings of sexual misconduct and UCR's termination decision. Therefore, there's no justiciable controversy and the appeal is moot. And that's at the stage where you're at. Now you get to go back and contest all of those because you've exhausted your administrative remedies. I mean, to me, that's what the state of the law is. I'm not saying that's, the legislature maybe doesn't need to change that, but now you've got to that point where you get to go back and contest all of those.
The legislature has been of no help in this area. It's all blood, sweat, and tears in the courts to try to remedy the damage that's caused, where they set up a policy that could malign somebody, make findings, and then there's just
And those
utter
cases
delay.
have substantiated that. And this one may too. Anyway, okay.
Thank you for your
Let's hear what
patience.
they have to say.
Thank you for your
Thanks.
patience.
So did we get it wrong that there is a process to attack the initial investigation and report?
I think that, Your Honor, with respect to the relationship between PPSM 70 and the SVSH policy, there's language in the tentative opinion that the Title IX investigation report will stand in as step one of the PPSM 70 process. And I do think that, respectfully, Your Honors, that's not quite right, at least my reading of the procedure. And I think the language that the court is citing to applies when the employee alleges that she or he experienced sexual assault or sexual harassment. And so the complaint that they're filing about a particular management action that's affecting the existing terms and conditions of their employment is that sexual assault or sexual harassment. So in that respect, that does stand in as step one of the PPSM 70 process. And then step two is an appeal of that. But I think that stepping back, you cannot deny that there's a relationship between the SVSH policy and the PPSM 70 process. And I think that's apparent in this case. And so I'll just take a step back and try to orient everybody. I think that I would urge Your Honors to affirm the trial court's judgment for two reasons. The first reason, I think, is undisputed that Mr. Doe did not allege that the PPSM 70 process was complete at the time that he filed his writ petition. So the second piece of that is that the Title IX investigation report is not a final administrative decision that is separately reviewable under Code of Civil Procedure, Section 1094.5. And again, as Your Honors pointed out, Mr. Doe may seek to review the Title IX investigation and findings as part of a challenge to the university's actions that it took in response to those findings. And in this case, that is the termination of Mr. Doe's employment. So I think that, nobody disputes that a litigant must exhaust his administrative remedies before seeking redress in the courts. And as Your Honor's tentative points out, the exhaustion requirement performs several important functions, and I think that at least one of those or two of those is presented in this case. And that includes a development of a more complete factual record in the event of later judicial review. And Mr. Doe attempts to get around the exhaustion requirement by arguing that there are two separate and distinct administrative decisions at issue here. The Title IX investigation on the one hand, and the termination decision in response to that investigation. And I think that it's one administrative process. The Title IX investigation and the findings, it's not a self-executing decision. If there's an adverse Title IX finding, the employee does not automatically get suspended, they don't get terminated. The process that's outlined in the SVSH policy, which my colleague pointed out, refers to the fact that after the issuance of the investigative report, the process includes contemplation of disciplinary action based on those findings. So to separate out the Title IX investigation and then the disciplinary action that is taken, that would not be taken but for the Title IX investigation itself, is to draw a clear line in the sand that does not make sense. It is all part of one process. And so we're asking, that we let the process run its course before we seek review, or before Mr. Doe seeks review of particular aspects of the process.
Which, according to the letters, it has.
Yes, that is correct. He has now completed it. Mr. Doe could have dismissed this appeal any day. He could today file a petition seeking review of the university's action, including the Title IX investigation and report. And so I think that the best way to think about it is that the Title IX process is inextricably linked with the termination process, the termination decision. And I think that the finality requirement is important, and one thing one of the reasons why it is important is because there are things that may happen later in that full administrative process that could provide color or input on things that happened earlier in the process. And by that I mean, through the PPSM 70 process, Mr. Doe is entitled to to seek review of a specific management action that affects the terms and conditions of his employment. He had the opportunity, and he did in fact argue that there was not good cause for the termination. And to review that termination decision necessarily entails reviewing the Title IX investigation and report that it's based on. And so he had the opportunity to raise issues with the Title IX investigation and report in relation to whether there was good cause for the termination. And I think that, I don't want to bring in facts outside the record, but as I said, the PPSM 70 process necessarily requires a look back at the Title IX investigation and report, because that is what the termination is based on. So like I said, there are things that could happen during that PPSM 70 process. For example, he could say, there was not good cause for my termination because the Title IX investigator ignored exculpatory evidence. And, you know, the person who is charged with assessing the PPSM 70 complaint does not have to accept the fact that exculpatory evidence was completely overlooked. They could say, well, there was not good cause for the termination because they ignored this entire thing that could have, you know, changed the outcome. I'm not suggesting that that means that the Title IX report is vacated and it's rewritten the way that you referred to the police report earlier, but it does necessarily entail a look back and a review of that earlier process. And so I think that there's a couple of other goals that the finality requirement supports.
Before you go on, I just want to make
Yes.
sure I understand your point. You're saying that without the Title IX evaluation, you can't have the termination, so the two have to be considered together.
Yeah, Your Honor, yes, in this case, Your Honor, that is true. I'm not saying that a person could not be terminated for other reasons. I mean, in this particular case, the record supports that Mr. Doe was terminated based on the Title IX investigation and the facts underlying that investigation. So I think there's another important interest that the finality requirement serves, and that's economy, judicial economy. The idea that the Title IX investigation report would constitute its own administrative decision that's separately reviewable, and then the termination decision would be its own administrative decision that's separately reviewable. A person who, unlike Mr. Doe, does think it's very important to not be terminated, to take a hard look at that termination decision, to potentially overturn that termination decision. Are they going to have to file two different actions? Or would that enable them to get two bites at the apple? I first challenged the Title IX report. I don't get the right response. I'm going to go after the termination decision, which, as I said, is necessarily linked to the Title IX investigation report. So in that way, we're going to have parallel proceedings when these two things are inextricably linked. So I think that, unless Your Honors have any more questions, I urge you to affirm the trial court's judgment on the basis that Mr. Doe did not plead, that the PPSM 70 process was complete at the time he filed his writ petition, and that the Title IX investigation is not its own separate final administrative order that's separately reviewable under Section 1094.5.
Okay. Thank you very much.
Thank you.
How much time remaining for appellant?
I think my colleague made the point that the step one in the PPSM 70 is not the SVSH action. It is the grievance or complaint on the termination action. I think if the court looks at the separate PPSM 70 action, there's no hearing required by law, that an action under that process might not even fall under 1094.5. What does fall under 1094.5 is the SVSH determination that there was a finding of responsibility by a single investigator employed by, who acted as police, judge, and jury. That was final. And I would urge the court to reverse the lower court, because it is a separate, well, that's our point. I think I've made my point clear as I can. And then as it goes forward through the PPSM, it's absolutely clear from the record that no one can look at the content of the report. They have to accept the finding of the SVSH Title IX report as fact. It's a given. So the only argument that petitioner has is, oh no, I shouldn't be terminated because I was found responsible. And the record's pretty clear that you have people reviewing their own decisions. There's a termination decision, and then that's reviewed by the same individual. That takes months and months, and then somebody else looks at it and just rubber stamps with no analysis whatsoever of the reasons for the termination. That delay alone can where they delay over a year, that's reason not to have to exhaust. And also, there's no judicial economy. Judicial economy would have been if it was nipped at the very beginning, when the final SVSH policy decision was made. Unless there's any other questions.
No, thank you. You've
Thank you
given
very
us
much.
a lot to think about, so we appreciate it very much. The arguments were excellent, and we'll take it under submission. Thank you. We'll call the last case for this panel.